The Trump administration has made some major changes governing how people who have filed an asylum application may apply for the legal right to work in the United States. These new rules have drastically changed both the process and who is eligible for work authorization. To be frank, the rules are punitive. They are clearly part of Donald Trump's war against legal immigration. In part 1 of these series, we talked about the rule that eliminated the 30-day deadline that was imposed on USCIS to make a decision on an application for work authorization filed by an asylum applicant. In this video, which is part 2, we're going to look at some of the rules that came into effect on August 25th, 2020, that also changed the process and the eligibility rules regarding work authorization for asylum applicants. My name is William Kovach, and I am a trained immigration lawyer. I've often been disappointed in the way immigration issues are talked about in the media, although it's not always their fault. Immigration law can be a very complex subject, touching upon constitutional issues as well as personal political points of view. My goal is to explain immigration law to you, concentrating on looking at judicial opinions and executive actions in order to explain how immigration law can have an impact on our community and on our country. I hope that you'll join me as we try to make sense of immigration law and how it may affect the average person. In my last video, I went over the asylum process, who your typical asylum seeker is, how the old work authorization regulations worked, and what U.S. Citizen and Immigration Services, or USCIS, had to say about eliminating the 30-day deadline on themselves to make a decision on work authorization applications. So if you're interested in any of those topics, I urge you, go see that video. I'll have a link in the description below. And there are timestamps in the description of that video, so you can skip ahead to the parts you're most interested in. In this video, there is a lot more to cover. And that's because the rules that came into effect on August 25th are very broad. They change a lot of things. They change the fundamental process of how an asylum applicant applies for work authorization. And to understand just how drastic these changes are, I think it is important to know a little bit of how the regulations worked before August 25th. In fact, before August 21st, which is the day that the 30-day deadline was eliminated. Basically, there were 3 numbers every asylum applicant and every lawyer who practiced immigration law needed to know: 30, 150, 180. 30 is the number of days that USCIS had in order to approve or deny an application for work authorization. 180 were the number of days that the law, the statute, said an asylum applicant must wait before they can receive work authorization. And so 180 minus 30 gives you 150. That's the number of days that you had to wait before you can put in your application for work authorization. And this made a nice, tidy process. You waited until the 150th day after you filed your asylum application. You put in your application for work authorization, and then on the 180th day, you got it. And all this was put in place because, well, there are statutory deadlines that apply to asylum decisions themselves, but with the huge number of asylum cases that are pending at USCIS, the deadlines for making a decision on an asylum application were usually observed more in the breach. That is, in recent years, USCIS has taken a long time to make those decisions. And if your application is before the immigration courts, well, the immigration courts have been traditionally overworked. So again, it's going to take far more than 180 days to get a decision on your asylum application. In immigration courts, can take up to 6 years depending on which court and how crowded they are. Sometimes it could take longer. But the granting of an employment authorization document, or an EAD, was essentially automatic. You just put in your application, you had your birth certificate to show your identity, maybe you had a picture from your passport. If you had a passport, you'd send a passport-sized photo. In fact, 2 passport-sized photos. You made sure that your fingerprints were taken so that your background check could go through. And quite frankly, your fingerprints should have been taken when you filed your asylum application anyway, because it's required. It's just automatic. You send in your application, you get your appointment to go get your fingerprints taken. So for asylum seekers, this was not a big deal. The biggest problem was waiting. So what did USCIS change and why? So let's go back to the final rule. The final rule was published on June 26, 2020 in the Federal Register. It's in volume 85 of the Federal Register, beginning on page 38533. And that final rule starts with an explanation of the proposed rule. And that's the requirement when you change the regs. You are supposed to publish a proposed rule, give some time for notice and comment, and then respond to those comments when you issue a final rule. With respect to the proposed rule, USCIS states, on November 14, 2019, DHS published a notice of proposed rulemaking entitled Asylum Application Interview and Employment Authorization for Applicants. In this proposed notice of rulemaking, DHS proposed amendments in order to 1. Reduce incentives to file frivolous, fraudulent, or otherwise non-meritorious asylum applications to obtain employment authorization, or other non-asylum-based forms of relief, such as cancellation of removal, and 2, discourage illegal entry into the United States. DHS also proposed changes to reduce incentives for aliens to intentionally delay asylum proceedings in order to extend the period of employment authorization based on the pending asylum application and to simplify the adjudication process. DHS proposed further changes to prevent asylum applicants who have committed certain crimes from obtaining an EAD and to make the decision to grant employment authorization to asylum applicants discretionary in line with DHS's statutory authority. So let's take these allegations one step at a time. Let's start with these supposed frivolous, fraudulent, and non-meritorious asylum applications. And this will go back to a time in the Obama administration where Congress was just not acting on anything, let alone immigration reform. There's still a huge debate in this country on what to do about the millions of people who have come to this country peacefully without a visa, the undocumented immigrants. We have come close several times to having legislation to address migrant workers, to address temporary workers in industries that rely on the cheap labor that Latin American workers provide. Jobs which, quite frankly, Americans don't want to take, such as cleaning in a hotel, picking strawberries. Jobs that involve a lot of physical labor. Americans don't like those jobs. They won't take them. No matter what politicians say about supposedly losing jobs to immigrants, the jobs that these migrants are filling are jobs that Americans don't take. So the Obama administration made a very intentional policy choice. That policy choice was exercising something called prosecutorial discretion. That's the idea that even though there may be people here who are violating the law, it's up to the executive branch to decide who gets prosecuted for what violations. USCIS and Immigration and Customs Enforcement, or ICE, they have limited budgets. They have limited resources. They can't strictly enforce all of the immigration laws on the millions of people who are present in this country undocumented. So Obama made a very deliberate choice to concentrate enforcement resources on criminal undocumented aliens, violent criminals. We're talking about the MS-13 gangbangers. We are talking about the people who are violent and very dangerous and ought to be put behind bars. We're not talking about the migrant worker who just wants to support their family, so they sneak across the border so they can pick strawberries, hopefully so they could get home. So they come here, work their tail feathers off, keep a low profile, and when they've earned enough money, bring the rest of their family over. These were people who weren't causing any harm. These were jobs Americans don't take. So President Obama just decided that he didn't want the enforcement resources wasted on those individuals. Let's concentrate on the undocumented immigrants who are a problem. Let's concentrate on the gangbangers. So they developed a process. ICE attorneys were just being instructed to administratively close these immigration cases, these removal cases in immigration courts, and then we'll just put them on the shelf and kind of forget about them. And as an attorney, if a client came to you and told you that they were afraid to go back to their home country because of gang violence or because police corruption, because those are serious problems in the Northern Triangle, the three countries of El Salvador, Honduras, and Guatemala. Well, if they gave you a credible story of fear, you would file an asylum application. But if you filed the asylum application while the case was pending in the immigration courts, and if there were at least 180 days between the day you went to court to file the asylum application and when the court set the hearing where they would hear the testimony from your client, because the delays were 3, 6, 12 years to get a merits hearing. Well then, as long as your client had a clean record, you could talk to the ICE attorney and get an agreement to administratively close the case. So then your client had legal work authorization, they could get a social security number, they could pay their taxes, and the case would just sit there, technically pending, but closed. This is the practice that the Trump administration wants to stop. But the problem is that USCIS is doing it in such an overbroad way that it's going to adversely affect legitimate applicants for asylum, people who have a legitimate case and a very good chance of winning. And the next justification was to discourage illegal entry. Well, there's a problem there, and we'll get more into it later in this video, but just to point out, the law passed by Congress prohibits the government from withholding asylum eligibility based on how you entered the country and whether you're in a legal status. In fact, international obligations binding on the United States prohibit a country from using illegal entry or illegal presence as a reason to deny asylum. As I said, we'll get into that. That's relevant for one of the changes that took place. First thing I want to note is the effective date. Which cases do these rules apply to? Except as noted below, the provisions of this rule will apply only to applications for employment authorization based on pending asylum applications and applications for employment based on parole that are postmarked, if applicable, electronically submitted on or before the effective date, August 25th, 2020. EID applications that were postmarked before the effective date of this final rule, accepted as properly filed, and are deemed pending on the effective date of this final rule, will be adjudicated under the respective prior regulations. So if you got your application in before August 25th, you're still under the old regs. Everybody who files an application now, you're screwed. So now, what are the specific changes? Illegal entry. DHS proposed to exclude from EAD eligibility any alien who entered or attempted to enter the United States at a place and time other than lawfully through a U.S. port of entry, with the limited exception of when an alien demonstrated that he or she, 1, presented himself or herself without delay to the Secretary of Homeland Security or his or her delegate, 2, indicated to a DHS agent or officer an intent to apply for asylum or expressed a fear of persecution or torture, and 3, otherwise had good cause for the illegal entry or attempted entry. In the final rule, DHS is clarifying that to meet the first prong of this three-part exception, the alien must present himself or herself without delay, but no later than 48 hours after the entry or the attempted entry. This is something that Donald Trump is trying to get through a regulatory change that he was unable to get through a presidential proclamation back in 2018. Back on November 8th, 2018, Trump and his Attorney General, Bill Barr, tried to create a rule that if a person did not come through a port of arrival or a port of entry, but instead tried to cross the border without a visa, basically, what the Trump administration was trying to do was to say, look, if you came into this country illegally, we're not going to grant you asylum. There's a problem. That is in direct contravention to the law as well as to international obligations. Now remember, President Trump has a great deal of discretion on immigration issues. However, in exercising that discretion, the president cannot contradict the express language used by Congress in the statute. So what does the statute say? This comes from Section 208 of the Immigration and Nationality Act, or the INA, subparagraph A1. An alien who is physically present in the United States or who arrives in the United States, whether or not at a designated port of arrival, and including an alien who is brought to the United States after having been interdicted in international or United States waters, irrespective of such alien's status, may apply for asylum in accordance with this section. Congress has made it crystal clear. Illegal entry, illegal presence is not a reason to deny asylum. And that rule is consistent with treaties that the United States has signed and ratified. So we're not talking some vague rule of customary international law. We're talking about a rule the United States voluntarily agreed to obligate itself to, and that the United States used the proper legal channels to make the rules binding. And those rules are contained in the 1951 Protocol on the Treatment of Refugees. This protocol is binding on the United States through the 1967 Protocol because it's mentioned in the 1967 Protocol by reference. And the 1967 Protocol is the protocol that the United States signed and ratified. Article 31, Paragraph 1. The contracting states shall not impose penalties on account of their illegal entry or presence on refugees who, coming directly from a territory where their life or freedom was threatened in the sense of Article 1, that's the article that refers to persecution based on the 5 protected reasons, enter or are present in their territory without authorization, provided they present themselves without delay to the authorities and show good cause for their illegal entry or presence. So why does this rule exist? Well, if you're coming here to claim asylum, it's because you have a reasonable fear of persecution based on race, religion, nationality, membership in a particular social group, or political opinion. Essentially, your life, your safety, your liberty are in jeopardy. You are escaping real danger. And if you're escaping danger, you shouldn't be punished for doing everything you can to keep yourself and your family safe. And that includes jumping the border if you have to in order to escape whatever it is that poses danger to you. And not surprisingly, the Trump administration has been sued over its presidential proclamation, and they lost. The case was originally brought in a U.S. District Court in California, and it was appealed to the U.S. Court of Appeals for the Ninth Circuit. It's a case called East Bay Sanctuary Covenant versus Trump. and the Ninth Circuit has agreed to a preliminary injunction preventing the Trump administration from enforcing a rule that would deny asylum to people who entered by crossing the border illegally. And why? Well, it directly contradicts the language of the statute. So Trump can't impose an outright ban on granting asylum to people who cross the border illegally. So his administration decides to use work authorization to achieve the same goal. Instead, they're going to make life difficult for legitimate asylum seekers just because they disagree with a part of the law that allows people who are here illegally or who have crossed the border illegally to still be granted asylum. And that's the main problem. This is going to deny the legal right to work to people who have a legitimate asylum claim. These are people who can and probably will be granted asylum, but they're going to be denied work authorization while they're waiting, based just on the whim of the president and his immigration people, based just on a judgment of the president and his immigration people that they don't like the law as it's written. So what's the effect of this then? It's punishment. It's punishment for somebody who hasn't done it the way the Trump administration wants you to do it. And why does the Trump administration want you to do it their way? Because they want to keep you out of the country. They don't care if you have a reasonable fear. If you go through a port of entry, Trump has another policy which will make you stay and wait in Mexico until your asylum case comes up for a hearing. That policy, by the way, is also subject to litigation, which has also so far gone against Trump. And also, as a practitioner, I would get clients all the time who would tell me that the people at the border, the people who were at the ports of entry, the CBP officials, would just tell them, no, America's closed. No, you can't apply for asylum right now because we're not accepting applications. They would abuse their power to keep people out and apply for asylum regardless of whether it was a legitimate claim. And now they want to deny work authorization based on the same reasoning. So the Trump administration can point to Article 31, paragraph 1, and say, wait a minute, it says right here in the treaty that the refugee must present themselves to the authorities without delay. So we're simply interpreting the words without delay to mean 48 hours. Within 48 hours, you've got to report yourself to an immigration authority and tell them you fear. Well, let's set aside for a moment the fact that this is completely unrealistic. Because if you've made it across the border and you're not immediately going to CBP, it's because you're more worried about your physical well-being. Most likely, you have relatives or friends in the United States that now you're hiding out with in order to get something to eat, change your clothes. And the hurdle for the Trump administration is that Congress has essentially already spoken on the issue of what it means to report without delay. And Congress did so in 1996 in legislation called the Illegal Immigration Reform and Immigrant Responsibility Act of 1996. Practitioners call this IRA, because that is the legislation that imposed the one-year deadline on people who are going to apply for asylum. That is, asylum applicants have 1 year from the date of entry to file their asylum application. And if they miss the 1 year deadline, well, then they have to show either exceptional circumstances that prevented them from filing on time, or changed circumstances that made it dangerous for them to go home that didn't exist during that first year. Now, there are different rules that apply to unaccompanied alien children, or UAC, but they're complicated. I don't want to get into them in this video. I will address them at some other time because they have changed, and it's important to understand those changes and know what you're dealing with. So let's take a closer look at what USCIS is saying about this rule applying to illegal entry. DHS is excluding aliens from receiving an EAD if they, on or after the effective date of this rule, Keep that in mind. That's another effective date issue. Instead of the EAD being filed on or before the rule, what matters is the day they entered the United States. Did they enter the United States on or before August 25th, 2020? Enter or attempt to enter the United States illegally without good cause. Of course, there's that question. What is good cause? Quite frankly, if you're fearing for your life, that seems to be good cause to me. And that's generally why you're applying for asylum in the first place. Good cause is defined as a reasonable justification. Good cause is defined as a reasonable justification for entering the United States illegally as determined by the adjudicator on a case-by-case basis. Since what may be reasonable justification for one applicant may not be reasonable when looking at the circumstances of another applicant, DHS believes a case-by-case determination of good cause in an adjudication will incentivize aliens to comply with the law to the extent possible and avoid injury and death associated with illegal entries. If the Trump administration cared about the injury and death to people who cross the border illegally, they wouldn't have CBP officers going out into the desert and kicking over bottles of water that volunteers have left in the desert so that people who sneak across the border can pick them up and avoid dehydration. But we have video evidence of CBP officers doing just that. So this is a pretext. The Trump administration doesn't care about people's safety if they cross the border illegally. The Trump administration cares about keeping them out of the country, period, even if they have a valid asylum claim. DHS believes these provisions also will reduce government expenditures relating to detecting, apprehending, processing, housing, and transporting escalating numbers of illegal entrants. So the Department of Homeland Security is worried about expending resources, yet they're creating a new process. Because now USCIS has to make an entirely new decision. They have to make a decision on whether an alien had good cause to cross the border at a place other than a port of entry. That means that the alien is going to have to submit evidence, documentation, an argument, hire a lawyer. There's going to have to be some type of hearing or interview, which means all the resources that they don't want to spend on one end, they're simply going to spend on the other end. So preservation of resources, when you're talking about creating an entirely new process, well, again, that's pretextual. Well, again, that's pretextual. To the extent that this change is alleged to be a penalty within the meaning of Article 31, Paragraph 1 of the 1951 Convention relating to the status of refugees, which we addressed, which is binding on the United States by incorporation in the 1967 Protocol relating to the status of refugees, which we stated. DHS believes that the good cause exception is consistent with U.S. obligations under the 1967 Protocol because it exempts aliens from the bar to eligibility for employment authorization if they establish good cause for entering or attempting to enter the United States at a place and time other than lawfully through a U.S. port of entry. Asylum is a discretionary benefit reserved for those who establish that they are genuinely in need of protection of the United States. It follows that employment authorization associated with a pending asylum application should be similarly reserved. But there's the problem. It's not being similarly reserved. It's being withheld for a reason that asylum can't be withheld for. So people who have legitimate need for the protection of the United States are going to be denied work authorization, but not asylum. In order to deter future illegal entries, DHS will apply these provisions to any alien who enters or attempts to enter the United States unlawfully on or about the effective date of this final rule. Look, I can't say this enough. Asylum applicants tend to be the most vulnerable people in society, and that's because when they realize that they're in jeopardy, when they realize that they have a reason to flee their country, they generally get what few possessions they can carry with them. If possible, they grab their family, like their young children, although at times they may have to leave the young children behind with grandparents or aunts and uncles. Depending on how immediate the danger is, they make the treacherous journey north. And believe me, it's treacherous, particularly in the northern area of Mexico that has the border with the United States, because that area is controlled by the Mexican cartels that smuggle drugs. It's a dangerous area. It's a dangerous journey. To take this journey, you really need to be in fear for your life. They come to the United States, they have nothing. They're not allowed work authorization for some time, even after they've filed an asylum application. And that's by law. They are reliant on the compassion and the benevolence of family members, friends, or service organizations. And now we're going to deny these people the ability to be self-sufficient, the ability to go out and get a job illegally so they can pay for their own expenses, so they can pay for their own legal representation on a basis that we can't deny asylum for. How is that anything but a punishment? How is there any equity involved with that? Plus, it's a redundant process. If you're applying for asylum, you fear for your life. Generally speaking, if you fear for your life, you're going to be found to have a good cause to come into the country and get protection of the United States in any way possible. Yet we're creating a new process and expending more resources. And for what purpose? It's to make the life of asylum applicants more difficult. That's the only purpose here. Make it more difficult so we can discourage more people from applying for asylum, and we don't care whether they're actually in danger. We just don't want them here. Let's move on. The one-year filing deadline. As I mentioned, anyone who wants to apply for asylum has 1 year from the date they entered the country to file their asylum application. That is, unless you have changed circumstances or extraordinary circumstances. Let me give you an example of how that could apply. Let's say we have a person who comes here to the United States on a temporary work visa. They're here legally. They could be here for maybe a couple of years, depending on the type of visa. They bring their family. Many of these visas allow for spouses and children to come to the United States. Let's say one of the children is a teenager, and let's say that teenager discovers that they're homosexual, that they're a member of the LGBTQ community. Well, being part of the LGBTQ community can put that person's life in jeopardy depending on what country they came from. Some countries routinely persecute members of the LGBTQ community. So that person could have a legitimate asylum claim. But let's say that person comes out of the closet more than a year after they've come to the United States. Well, the reason for their fear did not arise until they came out of the closet. So that person could still file an asylum application and make an argument about changed circumstances. Let me give you another example. Let's say a woman has come to the United States accompanying her husband who has a temporary work visa. And let's say while in the United States, she experiences domestic abuse. And let's say that abuse happens a year after she came here. Well, there are some cultures that are extremely chauvinistic. There are cultures that will say this woman needs to stay with her husband no matter what, even if the husband is abusive. And those are cultures where it may be possible for you to get an asylum grant from the U.S. government. But if that level of abuse didn't really occur until 1 year after coming into the United States, well, we've got the 1 year bar to contend with. However, you can file the asylum application and you can make a credible claim of changed circumstances. let's say you have a reasonable fear and you came here and with less than a year, you're in the hospital. Maybe you're in a coma for some reason. Let's say you stay in the hospital or the coma and it's past the 1-year deadline. Well, then you could make the argument that you've got an extraordinary circumstance that prevented you from filing your asylum application. The point is, there are people who can file past the 1-year deadline yet still be granted asylum. Let's see what the Department of Homeland Security has to say about all this. DHS is emphasizing the importance of the statutory 1-year filing in this final rule by providing that aliens who fail to file their asylum application within 1 year of their arrival into the United States will be ineligible for an EAD while their asylum application is pending until an asylum officer or an IJ, immigration judge, has determined that the alien meets an exception under the INA. Okay. Well, maybe that sounds reasonable, except when is a decision made on whether somebody qualifies for one of the exceptions to the 1-year deadline? Typically, it's not made early in the case, particularly in immigration court. The decision is made when you have your merits hearing, which could be several years down the road. If you're filing with USCIS, the decision is made at the time of the interview. In fact, sometimes the decision isn't even made at the interview. What happens is you have your interview, the asylum officer realizes that the 1-year deadline applies, and instead of deciding whether or not there are changed circumstances or extraordinary circumstances, they simply refer the matter to the immigration courts, which then means you're waiting several more years to get a decision on this issue. So even if you qualify, it means it can take several years before you're able to apply for an EAD. We're not going to deal with them here because of how complicated that subject is. We will deal with that in another time in another video. The point is that once again, people who are eligible to receive asylum are going to be denied work authorization for an extended period of time. And we're talking years. And why would the administration want to create this rule? Again, to make life difficult for asylum seekers, so we can dissuade people from even applying for asylum regardless of whether they have a legitimate case. Or we've got another problem. USCIS and the immigration courts may have to create a whole new procedure earlier in the process to make the decision on the 1-year deadline. So again, we're going to double the work in the case, double the need for expending more resources on the case, and of course, make life more difficult for asylum seekers, hoping they just give up. So what else does the Department of Homeland Security have to say about the 1-year filing deadline? As part of the reforms to the asylum process, DHS also is emphasizing the importance of the statutory 1-year filing deadline for asylum applications. Both DHS and DOJ-EOIR, that's the Executive Office for Immigration Review, and that's the agency that houses the immigration courts, because the immigration courts aren't really court, they're administrative agency. Under Article 2 of the Constitution, they're part of the executive branch. Both DHS and DOJ-EOIR adjudicate asylum applications filed by aliens who reside in the United States for many years before applying for asylum. Many aliens filing for asylum now are aliens who were inspected and admitted or paroled but failed to depart at the end of their authorized period of stay, visa overstay, or who entered without inspection and admission or parole and remained, not because of a fear of persecution in their home country, but for economic reasons. And there's a citation to a footnote. Footnote 83. What does footnote 83 tell us? Well, we see in footnote 83 that they're citing things from Public Law 103. That means the 103rd Congress. We see a report attached to the 99th Congress. We see a reference to a law passed in 1986. So the data that Homeland Security is citing to support that sentence is over 30 years old. How is it reasonable to rely on 30-year-old data for a change in regulations? It's not. There is no updated data cited in these regulation changes. In addition, the Asylum Division reports that a contributing factor to the asylum backlog is an increase in the number of applicants who file skeletal or fraudulent asylum applications affirmatively to trigger removal proceedings before the immigration court, where they can apply for cancellation of removal, a statutory defense against removal, and a pathway to lawful permanent resident status available to those who have at least 10 years of physical presence in the United States, meet additional eligibility criteria. Yeah, that happens. Let's talk about that. Cancellation of removal. It's available to people who are in removal proceedings, but they've been in the United States for more than 10 years. And yes, cancellation of removal can lead to permanent residency if you meet other requirements. But you can only apply for it if you're in removal proceedings in immigration court. So how do you trigger that? And let me tell you, as a practitioner, when you come across a case that is a good case for cancellation of removal, if you're not in removal proceedings, you've got to have a serious conversation with your client before you decide to move forward with this, because there are a lot of risks involved. Now, you could try to call ICE and say, hey, can you issue a notice to appear and start immigration court proceedings so we can apply for cancellation of removal? But the fact is, ICE doesn't like to do that. They don't like to start proceedings that they know they're just going to lose. So generally they won't. So another way to do it is to apply for asylum. And then if you don't qualify for asylum, at the end, you get referred to the immigration court. And when you get referred to the immigration court, well, now you can apply. So maybe the problem here isn't so much that somebody's figured out a way to trigger the cancellation of removal statute. Maybe the problem is that it should be easier for somebody who meets the cancellation of removal criteria to apply for it. But no, we want to deny people who have legitimate paths to permanent residency from obtaining the legal right to stay and work in the United States. DHS seeks to address this practice to incentivize bona fide asylum applicants to file sooner and to reduce the asylum backlog by making aliens ineligible for employment authorization if they fail to file their asylum application within 1 year of their last arrival in the United States as required by statute. Based on statute and relevant case law, DHS is also implementing exceptions to the 1-year filing deadline as it relates to eligibility for an EAD, namely for those who have met, as determined by an asylum officer or IJ, an exception under the INA. And as I mentioned, when is that decision made? Usually years down the road. It's not made early in the case. It's made when the decision maker makes a decision on the asylum application. So we're going to deny the right to apply for an EAD, the right to apply for work authorization, all the way up until the point that we make a decision on your asylum application, even if you would qualify for asylum. This is nothing but a punitive measure. So now let's talk about the expansion of the criminal grounds for ineligibility. In the Notice of Proposed Rulemaking, DHS proposed to exclude from eligibility for employment authorizations aliens who have 1. Been convicted of any aggravated felony as defined in the INA, 2. Been convicted of any felony in the United States or serious non-political crime outside the United States, or 3. Been convicted in the United States of certain public safety offenses involving domestic violence or assault, child abuse or neglect, possession or distribution of controlled substances, or driving or operating a motor vehicle under the influence of alcohol or drugs, regardless of how the offense is classified by the state or local jurisdiction. DHS proposed that it would consider on a case-by-case basis whether aliens who have been convicted of any non-political foreign criminal offense or have resolved arrests or pending charges for any non-political foreign criminal offenses warrant a favorable exercise of discretion. DHS requested public comment on whether these and additional crimes should be included as bars to employment authorization. DHS carefully considered the public comments received, including those suggesting that bars to EAD eligibility should align with bars to asylum. DHS disagrees that EAD bars must align with asylum bars. Okay, now here's one of the problems we have in general in society. When people are convicted of a crime, they now have become less than human. They become somebody who is a pariah. It's somebody who doesn't deserve our sympathy. That's just how society views it. It's why it's easy to come up with proposals to get tough on criminals. The problem here is what Homeland Security has just acknowledged. These rules are inconsistent with the rules of eligibility for asylum. And their excuse is, well, EAD eligibility, work authorization eligibility, doesn't have to align with asylum eligibility. Because Section 208 of the INA makes it so that a person who has committed a particularly serious offense is ineligible for asylum. And generally speaking, if you've committed an aggravated felony, as it's defined in the INA, it's going to be a particularly serious offense. But not always. But there's more. Now, any felony in the United States can render you ineligible for asylum. So that goes beyond what it says in the statute. Just because something is a felony under state law, it doesn't make it an aggravated felony under immigration law. In fact, there are some crimes that are actually misdemeanors in state law that are aggravated felonies in immigration law. And as I said, any aggravated felony isn't necessarily a particularly serious offense. So any felony, which is a broader category, may not be a particularly serious offense. Domestic violence, child abuse, crimes involving controlled substances. Those are not crimes that are specifically mentioned as a bar to asylum in the statute. And yet, here we are saying it's going to be a bar for an EAD. And why is this a problem? Well, we're adding additional punitive measures to people who would otherwise qualify for asylum. We're punishing people twice for one crime. These are people who may have already paid their debt to society. They may have already gone to jail and served their sentence. And now we're going to deny them the legal right to work, which is critical for avoiding recidivism, even if they qualify for asylum. Asylum is supposed to be a humanitarian act. It's supposed to be an act of compassion. And here we are adopting rules with respect to the work authorization, and they go against the humanitarian purpose of the act. They go against the compassion that is inherent in the Asylum Act. And once again, the only reason to adopt rules like these is to make life more difficult for legitimate asylum seekers. So we can create more of a disincentive for legitimate asylum seekers to apply and maintain their case. So now let's talk about so-called applicant-caused delays. In the Notice of Proposed Rulemaking, DHS proposed that any delay in the asylum adjudication requested or caused by the applicant that was outstanding or had not been remedied by the time USCIS adjudicates the alien's EAD application would result in a denial of the EAD application. DHS has considered whether the alien would have sufficient notice of the EAD adjudication date, which USCIS proposed to use to determine EAD eligibility, and determined that the alien would have little control over the date of adjudication. Therefore, in this final rule, DHS has amended the provision to provide that any delay requested or caused by the applicant that is outstanding or has not been remedied at the time of the initial EAD application is filed will result in the denial of the EAD application. Unlike the date of adjudication, the alien has control over the date of filing. DHS believes this modification will provide the applicant with certainty of their eligibility requirements under the applicant-caused delay provision of the rule, while disincentivizing applicants from prolonging the adjudication of their asylum application. Okay, let's talk about this applicant-caused delay. What does it mean? Well, let's say you have a case pending in immigration court. Immigration court has two types of proceedings. There are master calendar hearings and there are merit hearings. Master calendar hearings deal with the scheduling of the main case. The merits hearing deals with when the court hears testimony regarding the claim. Now, it could be that the first time you go to court with a master calendar hearing, you're not ready to apply for asylum. It happens. Maybe the client just came to you the day before. You think there may be an asylum claim, but you're not sure. So let's say that you asked for a continuance to have a new master calendar hearing so you can have time to further evaluate and apply for asylum. Well, immigration courts routinely grant that kind of a continuance. But if you ask for and get that kind of continuance, that's considered an applicant-caused delay. Under the old regs, it would cause the 180-day clock to stop and then restart once you're back on the master calendar and file your asylum application. Let's talk about something else. Let's talk about the actual evidence to support your asylum application. Remember when DHS complained about the skeletal applications? Well, sometimes you're under pressure as a practitioner to file the application as soon as you can to start getting these time periods to start running. So you may not have all the information you need. You may have enough to say, hey, there's a colorable case here. There's a potential asylum case here, but I need more evidence so I can make a better allegation. What you do is you file the asylum application, but you make your answers somewhat vague. You don't give that much detail so you can fill the detail out later. And the process lets you do it. If you're in immigration court, generally you're going to have 15 days before the merits hearing to file any additional information, any additional documentary information. If you're before USCIS, you're going to have 14 days before your interview, 2 weeks, to file additional information. And so you take advantage of that. Now, the statute requires your allegations to be supported by corroborating evidence. That's objective evidence that makes your statements more likely to be true. That corroborating evidence can be things like police reports, medical information, hospital reports, testimony from people back in the home country who know about the facts of your case. And when people are coming to the United States and they're claiming asylum, they're not coming with the idea in their head of, okay, how am I going to be able to prove my case? They're coming with the idea of, how do I get myself out of danger? So they may not be coming with police reports, hospital reports, statements from other witnesses. And once they're here, they may have to ask people back in the home country to go and get this evidence. Well, there are a bunch of hurdles to that. There's the language barrier. First, as a practitioner, you have to be able to communicate it to your client, which means you may need an interpreter. And then your client will need to communicate that back to the person in the home country. That may cause a whole host of communication problems. Internet availability in places like Central America is not as widespread as in the United States. That may cause a problem to obtaining the evidence. Delivery services don't necessarily deliver to every part of countries in Central America. There are some delivery companies that have a wider range of addresses they deliver to, but they tend to be more expensive. And then there's communicating both to your client and to the people back home exactly what you need. You may need the testimony from the witness back in the home country to address a very specific fact, maybe a very specific timeline. But a lot of times when you ask for these statements, what you get back is just a general statement that says, oh yeah, so-and-so is in danger, and we really hope that you give them protection in your country. Well, that's worthless. So then you have to go back to your client and you have to communicate why that's worthless, why they really need to go back to their relative or their friend back home and tell specific facts, why they have to say things like, well, I know she went to the hospital on this date. I know that the hospital is X number of miles away from us. That can be a very difficult task. Plus, people back in the home country may be reluctant to go and get the information because that calls attention to themselves. By asking for a police report, they could be marked for gang violence themselves. And let me give you a specific example. In one of my cases, I represented a Christian family who were living in a country that was overwhelmingly Muslim. The father had a fatwa declared against him. Now, a fatwa is when an imam, a religious leader in Islam, declares that a certain person is an enemy of Islam and therefore you have a duty to kill that person. It's a very good reason why you may need to leave your country and seek asylum protection. And you may not be thinking, boy, I better get a copy of that poster that's announcing the fatwa and encouraging people to take action against me. And if a person is helping you to try to obtain those posters, well, they may be putting themselves in danger because they're helping somebody who's been declared an outlaw. And even then, you need to translate that. If that poster is in a native language, it has to be translated into English. That all could take time, and maybe that means you need an extension. Maybe you go to the interview, and the interviewer points out some areas that they want you to go and explore. They want you to go and find more evidence on this point. That has happened. The fact that you were unable to present all of your evidence at the interview is going to be seen as an applicant-caused delay. So now all those reasons can work to delay your ability to apply for work authorization. Now all of this is related to the 180-day clock. That's the clock from the statute telling you when you're able to receive your work authorization. Now with the 180-day clock, it was the responsibility of Homeland Security and the immigration courts to maintain it, to figure out when there was a break and when you had to restart it. In fact, there's a phone number. You call this phone number, you can get information on a particular case that's pending before an immigration court. One piece of information you could get is where you were on the 180-day clock. So let's see what Homeland Security is saying about that. DHS is eliminating the 180-day asylum EAD clock and instead will deny EAD applications where there are unresolved applicant-caused delay in the adjudication of the Form I-589, that's the asylum application, existing on the date the initial EAD application is filed. The elimination of the 180-day EAD clock will resolve some of the difficulties adjudicators face in processing EAD applications. Calculating the current 180-day EAD clock is one of the most complex and time-consuming aspects of EAD adjudications. It requires multi-part calculations and the tracking of the start and stop dates for each individual applicant's case. It also requires coordination with DOJ EOIR for defensively filed cases that are not under USCIS's jurisdiction. In light of these issues, DHS is eliminating the asylum EAD clock altogether and instead extending the mandatory waiting period for an EAD. We haven't gotten to this yet, but we're going to, because that is very important. DHS also is notifying applicants that their EAD applications will be denied if their asylum case is subject to an applicant-caused delay at the time the applicant files the Form I-765. That is the application for the work authorization. DHS believes eliminating the 180-day asylum EAD clock will significantly streamline the determination of the date of the applicant's employment authorization eligibility while continuing to disincentivize applicants from prolonging the adjudication of their asylum applications. USCIS EAD adjudicators will no longer have to calculate the number of days that must be excluded to account for the applicant-caused delays or coordinate with DOJ EOIR to do so, and will instead simply rely on 365 calendar days from the asylum application receipt day to determine when an alien can request employment authorization. Basically, this is USCIS saying, oh, it's too hard. It's too hard. We don't want to do it. It's just whining over what their job is. And it's overkill. We're going to make it difficult. We're going to make it so that you have to wait longer to file in the first place. That's the 365-day. We're going to get to that in a minute. But we're going to make it harder and longer for people to wait to file in the first place rather than dealing with those cases where there is a applicant-caused delay. Overkill. You don't have to do this for everybody, but we're going to because, no, you just don't want to do the hard part. From the Federal Register, DHS is extending the time period an asylum applicant must wait before he or she is eligible to be granted employment authorization based on a pending asylum application from 180 days to 365 calendar days. DHS is changing the time period to a 365-day waiting period to remove the incentives for aliens who are not legitimate asylum seekers to exploit the system and file frivolous, fraudulent, or non-meritorious claims to obtain employment authorization or other immigration benefits such as cancellation of removal. Currently, if an alien files an application for asylum, the applicant can obtain an EAD after 180 days, excluding any days not counted due to an applicant-caused delay. Backlogs at USCIS and the years-long wait for hearings in the immigration courts allow aliens to remain in the United States for many years, be authorized for employment, and ultimately gain equities from an immigration benefit, even if their asylum applications ultimately will be denied on the merits. DHS believes that extending the waiting period for filing an EAD application will be a strong deterrent to those who may seek to file frivolous, fraudulent, and non-meritorious asylum applications. Further, in light of DHS's assessment that many asylum seekers are escaping general criminal violence and poor economic situations in their home countries, it is logical that more stringent requirements for EAD eligibility will disincentivize some of these aliens from coming to the United States in search of economic opportunity. And if you notice, there's this footnote 74. That is supposed to support this statement that there are people who are applying who don't qualify for asylum. You look at footnote 74, and essentially what they're citing is anecdotal evidence. Where are the numbers? Where are the statistics? It's not there. And there's a tension. There's that mention of general criminal violence. That's how the Attorney General, such as Jeff Sessions, has tried to have asylum denied if it's based on gang violence, even if that gang violence is so pervasive that the government is doing nothing about it or can do nothing about it. In fact, a directive from Jeff Sessions when he was Attorney General that asylum should be denied to people who are victims of gang violence and domestic violence, well, that's been the subject of some ongoing litigation. This is a judgment call on the part of conservatives and Republicans that people aren't coming here to escape persecution, but just to take advantage of economic opportunity. DHS also believes that this deterrent, coupled with the last in, first out, LIFO, asylum adjudication scheduling discussed below, will lead to meritorious applications being granted sooner and non-meritorious applications being denied sooner, which begs a question. There's an assumption there that the applications that are filed later, the ones that are filed more recently, somehow are either more meritorious than the ones that have been filed earlier. It's an assumption that this LIFO system is somehow going to lead to finding more of the meritorious applications than going by the applications that are pending more often. I don't see where you're getting at. I don't see how the applications that have been pending for so long are necessarily any better or worse as far as legitimate cases than the applications being filed now. Where's the justification for that? DHS acknowledges that these reforms will also apply to aliens with meritorious asylum claims and that these applicants may experience some degree of economic hardship as a result of the heightened requirements for an EAD. However, DHS's ultimate goal is to maintain integrity in the asylum process. DHS has determined that sustaining an under-regulated administrative regime is no longer feasible and that it is not unreasonable to impose additional time and security requirements on asylum seekers before they may apply for an EAD. There's an awful lot to unpack right there. For one thing, you have to consider that extending this rule, which is 365 days to file, not 365 days to get the authorization. You have to wait a year just to file. That is coupled with the prior rule that they no longer are imposing the 30-day deadline to make the decision on the EAD application. So if you wait this 365 days to file, you have no certainty over when you're eventually going to get the work authorization. That may take substantially more time. DHS is essentially removing all accountability for itself to make these decisions in a timely manner. So when they say that they recognize that some legitimate asylum seekers are going to experience some economic hardship, that's an understatement. People are not going to be able to work. They're supposed to be self-sufficient. We've made that as a society abundantly clear, that we want our immigrants to be self-sufficient. But this is preventing that. This is making it so they have to rely, asylum seekers have to rely on the benevolence and compassion of others to live, to have a place to live, to have food on their table, to seek medical assistance. You know what this is going to do? People are going to have to go to the ER more often, and how is increasing the waiting period any more of an incentive than the 150-day waiting period? Have you done a study in the first place to see that there's a disincentive for waiting an extraordinary number of days before you can file for work authorization to filing a frivolous application? And is there data that shows that if you extend that period from 150 days to 365 days, that the incentive is greater? It's not there. There's no reasonable explanation for this change. It's just based on an assumption that, well, if we make the time period longer, fewer people are going to file frivolous claims. How do you make that assumption? How do you come to that conclusion? I mean, just because you say something is more logical, it doesn't make it logical. You actually have to do logic. Perhaps the more logical course is just to reduce the backlog of asylum applications. How do you do that? You devote more resources to asylum officers. You devote more resources to getting the applications adjudicated. But again, that's too hard. Let's just make it harder on the asylum seekers. And we're going to use it as a blunt instrument. Instead of aiming it at specifically the people who we think are the problem, we're going to hit everybody. And what's going to be the result of that? It's going to harm even your legitimate asylum seekers. Or it's going to create more of an incentive for people who have filed an asylum application to work under the table, to work illegally, to work without authorization. Because how are you going to be expected to live for a year or more without being able to work and earn money? You can't. Now, as a technical legal point, illegal work does not automatically disqualify you from asylum eligibility. However, as Homeland Security is pointing out over and over, asylum is a discretionary act. And you have judges and asylum officers who will say, hey, look, you worked under the table. You worked illegally. Well, that shows me that you weren't really interested in receiving protection from persecution. You didn't have a legitimate fear. No, you wanted to take advantage of the economic opportunities that the United States has to offer because, well, you worked illegally. Therefore, I'm going to use that as one of the reasons to deny the exercise of discretion. Essentially, it's a catch-22. As I keep saying, it's designed to make life difficult for legitimate asylum seekers, so they give up. So they leave even if they have a legitimate claim, because this administration is not interested in the humanitarian purpose of the act. It's not interested in exercising compassion. It's interested in keeping people out, even if the law would allow them to stay and become permanent residents. It's meant to trap people in an illegal status perpetually. So what's the upshot of all these changes? Well, the Trump administration has now done severe damage to the process of applying for and receiving asylum in the United States. And remember, what can be done by regulation can be undone by regulation. So it's setting it up for a possible Biden administration to come in and just change everything back, assuming the litigation doesn't go against the Trump administration. But of course, we see how the Republicans in the Senate are trying to manipulate the process of appointing justices to the Supreme Court and pack the court with as many conservative-minded justices as possible. And that's going to have real-world consequences on things like immigration. It's also setting up an issue so that Republicans can make an argument when the Biden administration comes in and starts to try to undo the Trump rules. Now, the uneducated white voters who are the base of the Republican Party can be further manipulated. They can be convinced to say, hey, look, Biden's just trying to make it easier for people to sneak across the border, when all he's trying to do is bring things back to normal. And that's the thing. A Biden administration is going to have its work cut out for it on immigration law, as well as on many other subjects. There are a lot of things that were done by executive fiat that are going to need to be undone. Perhaps they can be undone by executive fiat again, or perhaps this is creating an incentive for Congress to finally act and pass some common sense yet compassionate immigration reform. The job that needs to be done in immigration to clean up after the Trump administration is huge. And if the Democratic Party can win both houses of Congress as well as the presidency, well, perhaps it will be time to stop delaying immigration reform and push it through with a comprehensive bill that will make America human again. Thank you for watching. Please remember to like and subscribe. If there are any topics you would like me to address in the future, please let me know in the comments below. Now, I don't like talking about this, but I am currently disabled because of complications following cancer surgery. If you're feeling generous, I'll have a link to my PayPal account in the description below. Thank you.